Advocate. Welcome Jyoti Srivatsav Advocate. I also welcome Advocate. These two are the practicing lawyers, very busy with their own profession. And I'm very grateful that they obliged us to spare time and give us the important input on various doubts we as caregivers have on the legal aspects of creating trust and managing the trust. Very essential. And most of the caregivers have no knowledge because this is an intricate legal and a trust deed, not a simple document that can be prepared by any advocate. And especially a trust deed when it is related to mental illness, we concerned as to have a well-versed knowledge with the Mental Health Act 2017 and also take into view the rights of the patient. The patient also has got certain human rights and how long a trust can be successfully managed depends upon the conditions and clauses we need to put into the trust deed after careful thinking. I think all of you are following Prabhakar or anyone is not comfortable with English here? English part, okay? All are comfortable? Okay. Huh? English? I just want to check in. And in fact, the help of Sarada, my sister, made it possible that it can be live telecast because of certain issues with so many caregivers. They are unable to leave the patient. Some of them are not comfortable today, and last week also but some are on the way. Some are on the way to come. But as the practice of ASMICA, I don't want to waste much of the time of the guest speakers too, because it is already live. If they're on the way, they will watch it. If they are in the house also, they will watch it. And this will be recorded. This session will be recorded and uploaded into YouTube. And this session will be available lifelong for ASMICA and other caregivers to follow it or get clarification again and again. So this is how we planned it, and I am thankful to my sister and my nephew in America. In fact, he also helped me to give connections to this YouTube on the last week. And this is how it goes. And in fact, before we proceed, it is my duty to introduce our chief guest to all of you. I think I have already circulated the rich profile of Jyoti Srivatsav, but still let us go through it so that you know the real profile of the advocate. He will address all of you shortly. Jyoti Srivatsav, practicing advocate. And in fact, you see the profile, each and every word I speak out here is to an objective, career objective, to uphold the dignity of the legal profession and serve the cause of justice with integrity, commitment and professionalism, while enhancing my experience in civil, criminal and family matters. I think you noted some of the words integrity as well as professionalism and other things. Academic qualification, Bachelor of Law, LLB Usmania University, Bachelor of Commerce, BCom, Amaravati University, Diploma in Business Management, Massey University, New Zealand. Professional experience, independent practicing advocate, Hyderabad, Telangana since 2019. 5 years of standing practice before various courts and tribunals, handling matters relating to criminal law, civil disputes, matrimonial, family and consumer law. Experienced in drafting legal notices, pleadings, written statements, affidavits, petitions and agreements, conducting legal research, client counseling and effective case strategy formulation. And she is a Bar Association member. Areas of expertise, legal drafting and documentation, legal research and case analysis, client counseling, trial preparation and argumentation, negotiation and mediation skills. India Book of Records holder, recognized for conducting 150 counseling sessions in a single day. Languages known: Hindi, Marathi, English, Marwadi, Bhojpuri, Haryanvi, Gujarati. Big claps. This is not a small achievement. Personal attributes: strong ethical foundation and sense of justice, excellent communication and analytical abilities, committed to client welfare and continuous learning. So I think the issue is not good to give you brief short time, but I think the achievements might have been much more. And I also introduce a colleague, Mr. Srinivas, himself when he speaks, and I think. And Madam, I think to the Chief Guest I would say, Madam, this is ASMICA, a Caregivers Association, which we formed 3 years ago. And we registered it as a non-profit organization. But since we have less resources, with the support of Asha Hospital, Dr. Jagannath is our EC member. We have been conducting our conferences here. And we have conducted awareness workshops by experts from schizophrenia and bipolar mood disorder and other things. And we are also represented the government of Telangana on issues of caregivers, which includes so many issues like your what after us is one thing. Government of Telangana is supposed to implement the Mental Health Act, Mental Health Act 2017. But as you know, in India, various states have fallen short of implementing this because Ministry of Family Welfare and this are not so active or maybe not prioritized this. And especially nowadays, as you very well know, that the suicides in youth Hello? Are you coming? I am in the session now. Please come. Okay. So as you know that the awareness, especially on mental health, is increasing slowly and step by step, and there is a telemanas which is started for emergency counseling, telemon services started. But they have fallen short of a lot of things which we have taken into the government through our memorandum, but has no response. We also conducted a dharna successfully, showing all the issues of caregiver, and also postcard campaigns to government, Ministry of Health. We met the Health Minister 3 times, and whenever we met, he talks very sweet and nice, and he says, we'll try to solve. But after we leave, I think nothing is happening. This is the continuous fight we are doing. But one more problem is caregivers themselves, being members here, are unable to spare much time, and they have their own issues and problems and other things. So taking this organization in a consolidated way requires committed people and who can spare time for social work. And I am trying to identify such people who can take ASMICA to proper this thing. This is a brief introduction of ASMICA, and with this, I think, few words, I request Jyoti Srivatsav Advocate to take over, and Mr. Srinivas also to introduce himself first, then Jyoti Srivatsav will take over the sessions. Thank you very much. Please, Srinivas, I invite Srinivas.
Hello, good morning to all. I am R. Srinivas, joined Jyoti Srivatsav from 23 December onwards. I have retired from the service in my law, and I started practicing law. And as the thank you.
Very good morning and namaste to all of you. First of all, I would like to say thank you so much, sir, for giving this opportunity to share my very little knowledge to all of you. And as sir has given the introduction of mine, again, I don't have to. Right? And I hope this session will, help you with your questions and answers and everything. I am here to help you all with all your questions and answers and legal. We will discuss everything. Regarding, as sir talked about, like Mental Health Act or Mental Act, like, yeah, I do agree with sir. To be honestly, government or any people, they don't take and they haven't taken the Mental Act seriously yet. And whatever he did was just it's kind of a very baby steps he has taken for that initiations for the Mental Health Act, that what should do and what should not do. But legally being an advocate, it is not something like where we can go with that, ki dharna karna hai and all those things. Being an advocate, I would like to share, like, there are courts and everything that where we can shake the government, especially. It is central government or state government. So we can go and we can file PILs against those. So yeah, I mean, so PIL is the best way to convey our problems legally and formally. That court notice, like, okay, this problem came with sir and we have to give that, like, solution. Because court is something like which will not leave you without solution. Going to any politician, what politicians they do? Nothing. They just, they'll promise. That's it. Those are like only false promises. I'm not talking about all the politicians. I don't want to get into all those things again because I'm a very neutral person. I'm not a political person. But yeah, there are some ways. We will sort it out, sir, with you, definitely, as I'm here to help you. Through PL, we can, touch the government and we can ask them, like, what is going on, why you're not giving those priorities to our thing, that's especially this. Coming for, the main topic is trust. See, in India, there are like thousands of families. They are and they have the same questions like you, that what after us? That is the biggest question any parents, even being me as a mother and being my husband being a parent, we do have the same questions at you, what you are having right now. What, kya hoga? Mere property ka, my FDs, my liquid, my fixed assets. After me, will someone look after them like the way I did it? Where, पैसे देख लो आप या फिर एक caring nature, both, है ना? So yeah, that is why our government of India, they have created a trust act, that is 1882. यहाँ पे ट्रस्ट होते हैं जो 2 टाइप्स के होते हैं, एक पब्लिक एंड एक प्राइवेट. प्राइवेट इज जस्ट फॉर आवर फैमिलीज लाइक दिस, दैट आवर डॉटर्स, आवर सन एंड फैमिली मेंबर्स एंड kin members should be protected, and we can register that family trust. There are some procedures, the legal procedures, where you have in private family trust, you have only 3 people, they are more important. That is settler, if sir is there, so like sir's property, whatever, the fixed asset or liquid asset, whatever you can. Liquid, as you all are aware, that FDs, mutual fund, cash transaction, whatever it is, jewelry. And fixed asset is non-movable house, anything related to XYZ. So here what we exactly do is, settler is the person who owns those property. Then again comes the second to the trustee who looks after everything. And finally, the main person is beneficiary, our kids, who we want to protect them from that. So it all depends, sir, that how you make a trust deed. That is more and more important. What are the clauses you need to put? There is not a restricted definition in private trust where you need to be restricted to the legal. Okay, you have to register that deed. That is, but clauses you can put as per a settler, after him or within, when he is alive. You can do it. There are this is the way that we can go with the private family trust. And kids with disabled, handicap, if they are mentally handicapped, if they are physically handicapped, then there should be the more special clause should be adding. That is our duty being an advocate, right? If you want me to go to that much legal, I'll be very much opening in the question and answer session, that one. And then again, going with those things, parties in the private trust should be settlers should be very well aware that what we need a very detailed regarding what exactly then example, this hospital, how what are the measurement of this hospital, who are the staffs, what are the assets related to this hospital and everything. We need a detailing about property, detailing about money, liquid, and everything regarding that. So settler can help trustee actually to run that very smoothly, so that that if trustee will run that smoothly, then automatically beneficiaries will get that advantage. Yeah. Who needs to make a trust? Yeah. Yeah, fine. We can continue questions as well. No problem at all. No problem at all. Ma'am, actually, to every person who owns a wealth, who owns a property, it is not restricted actually that, okay, I have a 1,000, can I make a trust? Yes, you can, definitely. If you're a very wealthy, if you have a family, who is dependent on you, if you don't trust any other person, whether it is a small or it is a big, you can go with trust. That is private trust. Yeah, if you are not sure about what will happen to your kids after you. until you are alive, it's okay for everyone being a parent that you will look after your kids, like financially, emotionally, everything. But again, trust is equals to the question, what will happen to our loved ones after us. That is the main motto behind, like, making trust, private trust. That any other person like who's having love, so we can go with the flow, no problem at all. Yeah, definitely. Yeah, sure. Yeah, sure. Yeah. So here, settler, I have already told you who is settler. Trustee, I have already told you, like, mentioned that who is trustee. No problem, I'll give you the photocopies what I have researched, like, for you guys to have a, like, you can keep all copy of mine as well. So here, not like, now why create a private family trust? We will go in a very little detail, okay? A private trust helps a person with a small succession actually, or smooth succession without any dispute. Now here, like will versus trust, right? Right? Okay. So will is something, ma'am, where we can, if suppose A made a will, okay, and after he passed away, any person from the family or maybe outside can go and challenge that will in a honorable court of law. But trust cannot be challenged. That is why we have to create a trust. Will is not like, secure document, though it's a legal document, but it is not a secure document to secure your future of loved ones. But trust is something where, like, private trust is something where you can secure dedicatedly. There are, like, reasons why people, they mostly go for the trust. We can take a example, big Tata, right? It's like 60% of the ownership is for the trust, and then trust he divided as per his wish. That is why we create a trust for succession we have. And trust always allows us to set aside our money, property, and constant income. No one can challenge that anywhere. Unless and until it is revocable or irrevocable, you can make it. That is the thing. And if you want me to give you, like, revocable is more, like, important for, people with, irrevocable, sorry, with people with mental disability or handicapped person who is not able to take decision, actually. Yeah. So for that, you cannot change unless and until settler is okay with it. Or is there any, like, clauses mentioned in the trust deed? The most important part of the private trust is trust deed. You need to be very, very, very careful while making that deed. Each and bit of the trust deed should be, like, detailed regarding how to run, what to put clauses, at what age you need to, like, hand over that person amount and anything, that how much time frame you need to, like, for that trust, you need to have that 15 years, 18 years, 25 years, 30 years. There are, like, lot of things where you can go with the trust. But will is like something where people, they will come and they will challenge and they will create that fake document. Will is something not like, right to go with wealth and everything, property. It is okay for the who's taking care, like, not with a good person who can challenge that in a court of law, with a good mental health. We'll talk about that, like, who are disabled or something like that, who cannot take their own decisions and completely depend upon others after us. So in that matter, yeah. Ma'am, legally I can't answer that, because it's the insurance companies actually, as usual. They have put the clauses. Even they have, even for the PMIs, even for the diabetic and heart patient, they do not cover actually, right? Am I correct, I think? So yeah, they don't cover those people as well, ma'am. The reason is only clauses, ma'am. It's all companies' comfort. That is the only thing. And every clauses and every, as usual, I have already said, like, since the thing I'm explaining this, I'm using the word clause. Clause is like you can, if you're making contract, okay, you can put your own clauses in that particular contract. So any insurance company is not made up of giving you any kind of a like profit or any insurance money. They always want to keep that money. They don't want to give you. That is why they put their clauses as per their wish. That is the only reason, ma'am. Yeah. Reservations. Reservations is a very big question. I agree with you, and I do like to share with you, ma'am. There is reservation in some competitive exams for handicapped people, that is PH, right? Physically handicapped, and if you are aiming for those things, then we both are ready to help you with that as well, ma'am. No problem at all. What kind of a? Yeah, civil services. That's it, right? Yeah, ma'am. If you are you will come in PH actually in that category. If you are, you have cleared that exam, written exam, and you have cleared the interview, no one will stop you. You are saying that you are mentally disturbed right now. Don't show those attitude in your, you are talking to me, I find you very normal. The way you are asking question and the way you are so yeah, that's good. Yeah, she is the Ira Singhal. She cleared a competitive exam. She became an IAS officer, even though she is physically handicapped actually. It's okay, I don't find it, ma'am, literally. Because while you're questioning, your questions don't sound me like you're mentally handicapped. Okay, now we will see what the clauses we need to put in private trust while making private trust deed. Should be name of the trust as usual, objectives, details settler about the details about the settler, trustee, beneficiaries, and trust property list is very, very important. That after that, you cannot amend it actually. If you are making revocable, it's okay. If you are not, if you are making irrevocable, then there will be a big question if that trust got registered with under the Trust Act. Rules of the investment and clauses, termination, you can though terminate at any time of your life. That as it's completely depend upon the settler only, what they want at. And the dispute resolution clause as well, that we advocates are there to help you guys, we will take a session for that. That okay, ma'am, if you want to go with the private making of the private trust deed, we take a very personal kind of a interview or a briefing, you can say in legal word, to to execute that private deed, private trust deed. So where we can mention a very, very, very little. And private deed is more important for only family ones and loved ones. That is a very if we'll go with the detailing, it will be hours and hours. But for all of you, I'm always available for your, if you want to take legal advice regarding this, I'm always available. No problem at all. You can come and approach me via phone, via WhatsApp, anytime. I would be really very happy to, assist you with that. And moreover, if you want to, yeah. definitely. That's what startingly I have mentioned. There is like in private family trust, we have three main people. One is settler, second one is trustee, who take cares of him. Trustee will always be, ma'am, your family, your trusted family members. And beneficiaries will be your kids and whatever to whom you want to. Along with your one family member, you need to have an advocate or a CA as a trustee. Yeah, advocate and CA to to handle monetary wise for the smooth running of the businesses, because there are lot and lot you're living. Just you're saying yeah, they will help. That is what I have already mentioned, and I'll keep mentioning again and again that clauses, dissolution clauses, dispute clauses, everything you have to decide. It is not that Indian Trust Act is limited to you can only put this much clause or this much. No. Until and unless your mind is in peace, then you can definitely put any clause to protect your person or your loved ones. Yeah.
Process of creation of trust, now members also. Let us start maybe at 11 o'clock. Now it is 10:30. From 11 o'clock, let us put the questions one by one, and the opportunity will be given to all the persons who have assembled here. All the persons. They can come one by one here and pose the question, so that we also listen to what question you have posed. Now, when you are interacting with directly, we are unable to. So please put your questions on mic, so that it will be recorded properly, and we also listen to the questions. Please cooperate. Let us conduct. Let the guest speaker finish the subject part, theory part. Then we ask questions. Thank you very much.
Yeah. So I'll take here one example which will cover everything. Okay, liquid asset and fixed asset. Okay, that is jewelry, cash, house, any property. Suppose Mr. Sharma is one person and his age is 55 or 60 in middle. He's got a residency or a house in Mumbai, and he's got 1 CR or near about that much cash, okay, and 80 lakh rupees of mutual fixed deposits, you can say, and a very small business he's running, okay, and he's he's got one daughter, she's minor, second son, he's also minor, wife, okay, and dependent mother, senior citizen. What exactly here Rajesh want, first of all, is children to receive money for education after his death, right? His house remain in the family, right? वो जाना नहीं चाहिए कहीं पे भी, shouldn't go with the auctions, loans and everything kind of a thing. The business to be managed professionally, right? So that will do like CA, along with his wife, right? His wife to receive regular monthly income to avoid any disputes among the family or from the family people. जैसी कोई हमारे सोसाइटी में, we are living in Indian society, जैसी कोई एक बड़े आदमी की डेथ हो जाती है, who owns a lot, who has got money and everything, then अचानक से suddenly that people they come and they started claiming कि हाँ उन्होंने ये विल लिखा था, उन्होंने ऐसे किया था, वैसे किया था, they did this and he did that, he said that orally take 1 CR from my wife. Suddenly, like many relatives, friends, they will come after his death, right? For securing that thing, he'll prefer with private family trust to make his everything. So how to create the trust now? That is what I have like covered everything in one example. Who will be the settler? Rajesh, right? Trustee, his wife, because he can trust his wife more, along with one CA and advocate. Either you can have an advocate, or you can have a CA, or you can have a both, right? For why trustee is needed? First of all, one family member is needed as a trustee in that particular process to keep an eye on an advocate and a CA, right? Ki kya chal raha hai, what is going on, where the profits are going, where the money is. And coming to the point ki ma'am, where how to put clauses and what clauses we need to put. You can put like, okay, monthly basis pe mujhe review chahiye. I need a monthly review. What is going on, who's coming, where the money is going. I need a complete review monthly. You can have quarterly, you can have yearly. It's all depend upon your wish, right? And then just property details, that is house, FD, mutual fund, business details, right? Everything that is collaborated at one place, right? Now, trust deed. Trust deed is the most important part of the family trust. What you say, what you put, what is in your mind, what are your securities, what are your insecurities. While executing this, you need to be very clear, ma'am and sir, that what you exactly need, what you're actually what your fear of. Some people, what they made a mistake while drafting trust deed, family trust deed, that they hide many things actually, not to get advertise out. Okay, we have a family issues and we do have that. Where at that point that became useless then. Family, private family trust deed is a very, it's not just a legal document. It is a safeguarding, it is a kind of a weapon where you are just safeguarding your loved ones, your kids, your dependable after your death. Right? So, yeah, exactly. I mean, this is what we have. And the benefit, after Rajesh will pass away, when he is not alive, there will be no legal fights, first of all. In India, we are living here in kind of a, what you will say, country where every family, they have issues. Property, money, they end up in court of law. And court will entertain court more think about not emotional, but they will more think about the documentary evidence. Okay, if someone will come up with a, one bill, one will he will come up with, and court will accept that will. Okay, if you have a problem, then go and challenge it. It is a time-taking process, right? Because our judiciary is not that too fast in India, right? So yeah, that is the more important thing, that there is no legal fights and probates. Probates in the sense, no one can, again, I'll come up with the same point. No one can make a fake will and no one can come. So probate is completely secured here. Assets are protected from the outsiders. जैसे कोई मरता है, पहले आ जाते हैं, लोन लिया था, ये लिया था, has taken loan against the bank and everything. Orally he will come and he will say and he will admit. So obviously after the death of Mr. Rajesh, family members got into trauma. Now what? So private family trust will protect you from that thing. Then clarity and predictions, mostly because in deed, you have already mentioned clearly what you want and what you're looking for, right? So you're protected with that as well. And smooth income without sending your loved ones to earn outside bread and butter. While sitting at home, they're getting everything. Only just with vigilance, right? But here, more important point is trustee should be very, very, very important person to whom you are giving all the authorities. Because in many NGOs, many trusts, we find like, frauds happens many times. They think like that because money is kind of a person will make greed to everyone. You can't protect them with that. But yeah, you can make there are many different types of trust where we can find that is irrevocable, irrevocable, main important which we follows more actually. Revocable, you can revoke anytime by putting clauses, right? Irrevocable for the a person who is not mentally able to take decisions. There has to be some strong clauses we have to put. Again, sir has mentioned that mental act and everything we have to consider. And again, I'll come to the same point. That also doesn't work in many cases. हाँ ठीक है, mentally disabled है, physically handicapped है, it's okay. हम लोग उसको कैसे भी घुमा देंगे. So where you need a person with a trust, with family person with a trust. So yeah, this is the Rajesh example. I hope you all are clear. इसमें मैंने पूरा complete cover किया है कि छोटे में ही बिल्कुल एकदम कि what you need to be very very what your clearance should be there, what you need and to whom you should give your authorities and how much. Now coming to how to make trust deed and how to get registered. That is our part, legal part. Most important you need for making any private trust deed is name of the trust, objectives, why you want. That is again, you can't hide anything. Like, nahi, it's okay. Just like I woke up in the morning and I got fear, I'll die. What will? No, that is not the main motive. Here we are not like making any kind of a will. We are making here like a trust deed, where everything is depend upon on your single word, what they are thinking and what you want to put. Every single word, every single clauses, everything. So details about the settler, trustee, beneficiaries. Beneficiaries, if they are having mentally disabled or physically handicapped, we need like medical certificate, hospital details regarding that. Because many times, many people they do for tax assumptions. That is the more and more important point is why we make trust to save taxes. Tax assumptions is the main clause of many big trust. जो कि every day they do the same to save tax. That is why we have to get the detailing about why, what are the objectives and why you want to make a trust. Then powers and duties of the trustees, you can, again I have mentioned, powers and duties you only can decide. Only settler have the authority to decide everything. Who will be the beneficiaries, who will be the trustees, and what are the powers should be given to the trustee. Right? Succession plan for trustee. What after? If something bad happened, something good happened. Both positive and negative. It should be kind of a 50 detailed papers while making a private trust. It doesn't really matter. If you're going to any advocate, just eat their head. No problem at all. Because it's a question of a person to whom you want to get secured. Right? For their future is a question of future of their after you. So yeah, dissolution and termination clauses. Why to dissolve and when to dissolve, and termination clauses. What happens if this will happen? Then this will get terminated automatically. Accounting auditing clauses, that without the signature no one can audit this and no one can signature, and there are other many other clauses we can go with, dispute resolution clause. Again, if something dispute will come, that trust deed will automatically get dissolved. So clauses, they don't have limitations. You can put whatever you want. And after that, we can get registered with under Indian Trust Act 1882. We get that proper document that we make it like legal document to get registered, and that becomes a legal and fixed document. Yeah, this is like, with a very kind of a, I tried actually. Maybe I'll be more clear in question and answer of yours.
She has covered the basic part of trustee, having the settler, trustee, the beneficiary, and also a protector. You can have a protector so that you can watch whether the trustee is acting as per the trust, or you will also discuss whether this particular act is beneficial or not, and on the advice. But the ultimate decision rests with the trustee. So it is important we know that trustee, selection of the trustee is more important, and also continuation of the trust. So we have a lot of questions on this legal complications that may arise out of the well-created trust deed, however best is right. And one more thing also, we will focus on members with their questions. We also focus on whether the patient himself can reject the trust, because a patient who is stable says, I don't need a trust. Why my properties of my parent should be handed to a trust? This is also because they have the right to act. Whether the patient himself doesn't cooperate with the trustee, what happens? These are all things we discuss. Now we request the beneficiary for madam to come and pose a question here in the podium, because we also will have a round of who are sitting here.
It's a little personal. I have nobody to pass on. I have a property of my own, but I have nobody to pass it on. I mean, there are family in the US, but I want to make sure that my property is used for some other purpose, good purpose, and somebody take care of me. I have medical facility, but if I fall ill or I need some home care or something, I need some finances for that. If I give the property to somebody, a trust of a form, and maybe that can be forwarded to somebody, or that has to be decided. I haven't thought of anyone. But will they help me medically? That is what the expenses and till I'm alive. If the property is also, I use the property for my gain. That is the thing.
Here I will ask you one question, ma'am. Do you have kids? No kids at all. Okay, fine, no problem. So, yeah, is it self-acquired or ancestral? Okay, right, it's for parents. So fine. After you, there is no Okay, so okay, fine. Ma'am, to be honest, in your situation, it's an ancestral property, right? So you can there are two types of property, self-fund and ancestral. In ancestral property here, I think I should suggest you that you should go with a will. That is registered will, along with a trust of your share. Do you have that in ancestral property, do you have a partition deed with you? Gifted it to you. And along with that gift deed, do you have any NOCs from your from your brothers and sisters? siblings, any no objection certificates from your siblings? No, that can be challenged. Okay, so is it registered gift deed or? Okay, ma'am. So in your case, like we have to attach that NOCs as well, ma'am, with your siblings. In your case, will is more important for you here. That you need to go with a registered will. That okay, this is a person in my mind. I will take care of, like if a person who is take care of that physically, mentally, financially, and my medical expenses will be like जो भी पूरे जितने भी मेरे ज़रूरतें हैं वो पूरी उन्होंने अगर कवर करती हैं तो मेरा विल उनको जाएगा along with a trust. No, fine ma'am, they are like class 1 legal hire. You are class 1 legal hire and your kids or your brother and sisters, your siblings kids, they are class 2 hire. So class 2, class 3, they can challenge up to 3-4 generations, ma'am. Yeah, they can come and they can challenge. Better for your option to secure your life. So you should go with registered will along with a trust. That is the best option available for you. Same. Looking after your medical expenses, you will get like a smooth income from like maybe 25,000 is fixed for like your FDs and your all the savings you have and whatever you are having. Yeah. So you can have a smooth running income, and by using that income, you will be securing your medical expenses until you are alive. Right? So in your case, I think you should go with a registered will and a private trust. Yeah. I mean, I don't know how much you have. It completely, again, more opinion will be depend upon like your case to case is depend upon, and more what you have. Yes. Yeah. Yeah. Again, I'll take you back. Like what I have mentioned in my like session, that whether it is fixed deposit, FDs, or liquid assets, your jewelry, your property, everything that counts, ma'am. Yeah, that counts. If you if you have like without nominees or no, so it completely depend upon your like situation. This is the basic situation you have given to me, so I have given the basic things. If I'll come to know about like if you have a FD and to whom you have made nominee, then we can go with that. So how that will get secured? By making private trust, because you have already made a nominee here, right? You have all. No, you have to show, ma'am. You have to be very sure at this age. Ma'am, I mean, I'm really apologize for here by saying this. I'm very, I mean, I don't have that much experience which you guys carries right now, okay? But I have seen many cases, ma'am, since years I'm practicing in the court of law. I mean, one day I saw a mother, she came to like, court and she started crying. Why? Her son actually, he started blaming his mother. क्या दिया उसने, कुछ नहीं किया, मैंने बोला था क्या पैदा करने के लिए. And fraudulently, like he took her signature on the blank paper. She started crying and she was begging in front of the like that bench and judge. Like even judge was aware that okay, that he did some fraud, and here we have to make a decision in favor of that mother. She cried, and ultimately that decision got against her. And no emotions, ma'am. I mean, what is the beautiful relationship between more than mother and a son? पेरेंट्स और किड्स का इतना ब्यूटीफुल रिलेशनशिप रहता है, उसको भी मैंने चैलेंज होते हुए देखा है कोर्ट में. सो आई विल नॉट गेट अग्री विथ योर व्यूज ट्रूली दैट अंटिल नाउ नो वन इज हरासिंग, नो वन इज टेलिंग मी एनीथिंग. मे बी यू आर राइट नाउ यू आर गिविंग मनी एंड यू आर प्रोवाइडिंग एवरीथिंग टू देम. मे बी दिस कैन बी. स्टॉप डूइंग दैट, यू विल नो द ट्रू फेसेस ऑफ देम. Yeah. So it completely depends upon case to case. where and how. Yeah, ma'am, sure. Yeah. We need complete detailing to give you advice, ma'am.
In between members coming and posing questions, we have one online question from Ritu Ahuja. Okay. So, Ritu Ahuja asks a question. Who will take care of the portfolio from time to time? Particularly, I think trustee. How should the movable assets portfolio be diversified for ease of maintenance, keeping in mind inflation cover and lifetime provision to loved ones?
I'm not a government, to be honest. Yeah. How will take care of the portfolio from time to time? How should the movable assets portfolio be diversified for ease of maintenance? Keep in mind inflation cover and lifetime provisions to loved ones after that.
Somebody has bought 10 shares in 1990, and at the time they bought it for a 10 rupees. They forgot their father had taken some their father. They found it among the cost of rupees.
Exactly. So inflation, we can't take that things. Okay, we can again. I'll tell Ritu ma'am that basic only. What it is movable and related to immovable, both we are covered. In Rajesh example, we have already seen that he has got like cash, he's got FDs, mutual funds, small business, and he has got like house, everything. So that we covered movable and immovable both, where you can put clauses. We cannot go that after 10 years because we cannot predict our death, right? To be honestly, we cannot predict our future, to be honest. We cannot say what is going to happen in next 5 minutes. Forget about like years and years. Nowadays we are sitting in Asha hospital. So this hospital like knows very well, better than me, that what is the meaning and the of every second of breath. Because a 21-year-old is also getting heart attack right now. So this is ma'am is talking about this very future. But yeah, to be very honest, we can take care of while clauses, we can put the future clause. While if it becomes according to the current amount and the current dividends of the shares, for example, that time whatever the price will be for that, we can go with that clause.
Welcome, two more members.
Only CA and advocates. Advocate will take care of every legality related to the trust, each and every reality. And CA will take care of this kind of a inflation economy, everything related to money matter. In a very civil language, I will share this with you. Like CA has got the power where he can manage everything. That you have to, okay ma'am, this is come, we got this much, what we have to do. My advice is like to go with this. Today's rate is this much. I mean, if sir have mentioned about the shares. Okay, share I have purchased like rupees 10. Now ma'am, I think my opinion is to trustee. To trustee that CA will say, okay ma'am, my opinion is now you can sell that. If with all your permission, I will say that. So we can, by like CA's advice, we can handle this inflation kind of a monetary thing. We can handle economy, whether it is bad or good. I hope I'm clear. Very tricky and very deep, sir, actually. Very, very deep.
it is growing also, inflation. And how much property you have and what is the lifespan of the patient. Both are, lifespan of patient is also unpredictable. So how much of inflation you could cover also. But this is a safety tool so that no, is not exploited. And the trustee also cannot exploit because he is conditioned by the trustee. So this inflation is something which cannot be immediately addressed to unless we give again powers of recategorization and reinvestment of the assets given in the hands of, that will again a classification where if the trust is also a very experienced man only we can trust him. But when you give so much of freedom to the trustee, it may result in anything because stocks are there, and if you give freedom to him to reinvest and reallocate stocks, it may end up in losses and because of conditional. So the thing is, we have to have a minimum safety tool, and once the properties are in the trust deed are exhausted, then the responsibility of the trustee is over because there is no trust without any assets are concerned. Now I request Ramakrishna Raj to come and ask any specific question he has on the front.
Actually, I am not prepared for this meeting. Okay. My brother is admitted ICU, so but I wanted to come here. Okay. See, one question I my personal situation. My daughter is an American citizen. My spouse is a schizophrenia patient. Okay. Now, in this trust, and now my daughter is major. Okay. She is doing graduation. So how do I build this trust? Because she is an American citizen. Are there any clauses involved here?
Private Family Trust, that is Indian Trust Act 1882, covers NRIs as well. Yeah. With special clauses and with a clarity. So you are not restricted, to be honest, that okay, if she is an American citizen or an NRI, that is it valid or legal to, like, you know, make her a part of this family trust? Yes, legally she can become a part of this trust. Just make her trustee, okay? Settler will be you, and beneficiary will be her as well, along with your wife. Yeah, fine, no problem at all. Yeah. Yeah, because no, we have got, like, you know, Indian government has collaborated with many, like, you know, moreover I speak about US only, had collaborated, like they should not leave, like, you know, their rights in Indian, like many people, they have property issues and all those. If she is having OCI, the great point actually, but yeah. So she is, I'm very much sure and 100% sure that she can become a part of a private trust. And she can become a trustee, she can become a beneficiary along with your wife. Yes. But Written, truly in your personal case, yeah, I'm 100% sure that your daughter can become a trustee and beneficiary along with your, your about and the clauses. It's all again. I'm saying it's your complete freedom. That particular piece of paper, you can have your complete authority and freedom. What you want to control, to whom you want to control, to whom you want to give authority, where you want to get okay. Done, khatam, ho gaya. You have that much authority, being a settler.
Can I wait for this trust deed? I meant to say in future, because now I am alive, I will manage things. I am alive, I will manage things as a caregiver for the PMI. Okay. So can I prepare a trust deed with a future date? I am saying that with the event link. Yeah. Okay, and the other question I have is, can I have multiple trustees?
Multiple trustees will, in very special condition, you can have, but that will be risky.
No, the reason I will link them to the events again. Say, for example, trustee 1, trustee 2, trustee 3. Okay. Correct.
Apart from your daughter, you can do it.
What is the cap? What is the cap? So, okay, fine. I think I am missing trustees and also you said some other words, but not beneficiary. Protectors or some, who is a protector? See, if I want to, see, let me take my case again. I want to put my friend and my sister as trustees. Can I do that along with my daughter? Yeah, if I am trusting them, yeah, I'll put that. So,
very deep. Okay, again, who is the friend, whether his property is self-acquired or ancestral, again that come clauses, just like ma'am, in ma'am's case we saw. So it's completely depend upon case to case. If it is self-acquired, if he acquired self, then it's okay, he can make it, no problem at all. But if it is ancestral property, again then no objection certificates and settlement deeds, there are n number of documents you needed for making clause. And if you will add in ancestral property, if you will add that person, your friend, that will become a public. And ultimately government will take over that. I don't want of giving anything to government. Right?
Yeah. See, in my case again, I have a ancestral property, and there is a will for that without being registered. It can be challenged. Okay, fine. And I have self-acquired property as well, 2 of them. And on the will, one of the siblings is a witness. It's not registered. If I can get NOC from my siblings. Okay. Fine. That's my questions. So now, you said succession certificate should be there. But but I have a family certificate, not a legal. Okay. So, okay, then. Nominee may get the money, but again, all the legal heirs are eligible to get that money, right?
If you are going like to challenge, if you think like no one can challenge that thing, go to court and apply for legal hardship certificate and succession certificate. Both will protect you for everything. Attach the will. Will is the most important. See, here will is important in ma'am's case, actually. Along with will, she can go with a private family trust. She can build that. Only in someone's matter who is only like, okay, fine, I don't have okay, he can do it like, he can go with the option of private trust. He can go with. In your thing, it is the ancestral property. So it's a long kind of a process that you need to follow. So again, most important document in your case is, sir, succession certificate, legal hardship certificate, and moreover, will. And come after like collecting all these 3 documents, then go with a private family trust. That will be completely 100% secure. Well, that again depends upon the trustee you are putting.
It is very clear now that will can be challenged, but private trust deed cannot be challenged. Okay. So trust deed is far superior than the will. Okay. But if a part of the assets you want to give it in will, you can give it, and the other part, how much of assets you want to give it to the trust, you only the decider as far as this is concerned. So always the trust deed is far better than the will, okay, which can be challenged, especially an ancestral property. Then as far as nominee bank is concerned, nominee is not a title holder, he will not get rights to use anything, he is only an intermediary. So again, a nominee also is guided by the trust deed, where you write a particular FD, interest on FD has to go to the beneficiary, nominee has to follow that. As simple as that. Now, Ritu Ahuja is here and he wants more clarification. Ritu. Huh? Huh? You are Ritu. You got you gone. Okay. Now, Ahmad, please come. Ahmad. Others also please think of your questions and be ready. This is a very great opportunity you are getting.
Madam, now trust deed and it is there, suppose. Again, registration of society is required for that. Both are required. How?
Registration is most important and mandatory process of the trust. Yeah, it should get registered with under Trust Act, Indian Trust Act. That is mandatory. Without, registration, it's nothing. That is only a piece of paper.
Suppose the ancestral property 40 years back, forefathers has given to their children. Now, for example, for me. Now, that mutation has not done. What to do now?
back to the ancestral property, I would like to ask you, like, have you received partition deed? Again, that is registered or unregistered. Yeah, so anyone can challenge, and that is a mess actually in your case, sir. Because unless and until how many siblings you have, how many brother and sisters you... you're in physical possession, you're saying, right? It's completely good. So your case is better than others' case now. Okay. So now it's a high time for you to go with, like, legal kind of a work. Get the mutation done, sir. And get the no objections from every of your siblings. Like, because anyone, as I have already shared, like until 5 generations, people can come and challenge. Right now, if you are in physical possession and you're controlling everything by your own, you're saying that, sir. But if someone XYZ will come again and he will say, no, no, I'm paying tax. This is my slip. So again, what court will do? Okay, fine. Sir, now it is contested. Yeah, then mutation is not there. No? See, yeah, in and moreover, it's a paternal or maternal from your mother's side or your father's side. Father's side. So 5 generation can challenge, sir. And from mother's side, if it is maternal property, ancestral property, then definitely up to 3 generations. 3 maximum you can stretch. I mean, many people, they don't have a idea about, like, okay, we can go, and some, like, they can like challenge until 4 generation. It is called decree. First, second, third kind of. And we are in Telangana. So nowadays, like Telangana people. Oh, which document, sir? Here I would like to share one more important thing, that I know, like, I mean, being an advocate, I will say that anyone is coming and any one of you is going for making any kind of a legal document, where you need to, like, keep in mind more important points. First of all, that should be, if it is immovable property, that should be like, like 100 rupees stamp paper, and that should be attested and notary. Should be done. Randomly, what advocates usually they do that, they'll purchase like 100 rupees of bond paper and they will just draft. And drafting is more and more important here again, that what he is doing, what he is putting. Because many of the advocates, they leave the main clauses actually. आपके इसमें, आपके कंडीशन में सर, वो डॉक्यूमेंट देख के ही पता चल सकता है कि उन्होंने क्या डाला है. और वो अगर अटेस्टेशन और नोटराइज हुई है, देन डॉक्यूमेंट हैव अ लिटिल वर्थ टू टेक और इन फेवर और अगेंस्ट ऑफ यू इन द ऑनरेबल कोर्ट. तो यहाँ पे जब भी आप कोई भी बॉन्ड पेपर यूज कर रहे हैं, दैट शुड बी नोटराइज एंड दैट शुड बी अटैच्ड बाय अ पर्सन, लीगल पर्सन. सो इट्स कम्प्लीटली सर, इन योर केस, आपके इसमें डिपेंड करता है अभी. और मेरा एडवाइस यही रहेगा कि गो फॉर अ म्यूटेशन एज सुन एज पॉसिबल. That someone should not come and challenge your thing. Sure.
Now I request Anuradha to come over to the dais and put a question, because it is for the benefit of all the people. So they would like to.
you could have included a child with the PMI who is a dependent child of PMI and various clauses, and what Rajesh would have written in his custody, the number of different scenarios, it would have been more helpful to us. So here he has got 2 normal children. Rajesh has got 2 normal children. Whereas if you would have given us an example that one person is an BMI and more relevant. Next is firstly most of the dependent children, they are here at least. They are mental illness. So in the mental illness, mainly it is of 2 types. One is bipolar and the other is schizophrenia. In bipolar, such types of PMIs, persons with mental illness, have 2 scenarios. One is they have depression or they have mania. Mania, I think you understand mania. They have, depression is like opposite to depression. Then schizophrenia, most of the patients here is they don't have any insight. That means they are not in contact with reality. So definitely, but when they are stable, they are partial insight. But when they are not stable, they are not in a position to make a proper decision. It's relevant to themselves also. They can't take a proper decision for their welfare also. In that case, so most of us here will have no other option but common trust. Okay. My question is that in the Mental Illness Act, huge powers have been given to a PMI. Now, if you have to give us guidance. What you are asking us are preferences. Like we should tell you what are the values. Here we are at a loss. So most of the people here, they would like to have a draft clause, and then from there maybe we can pick up what all in future we will be needing. So, and everybody, 50% I think have a common requirement. The other 50 would be personal. It will differ. 50% will be like we have an X amount which we will be putting in a trust. We will be describing the trustees also. That part is common for 50% is common. But the next would be like their source of income, or like you said, some may have movable, some may have immovable, some may have fixed deposit or mutual funds or whatever. Secondly, we must keep in mind that there will be two assignments given to the trust. One would be the financial, which may be taken care of the chartered accountant. The other would be the day-to-day management of a PMI's life. How do we address that? Who is going to take care of that? Out of the trustees, one will be given the power or one will be given the duty to run the, and again, with the PMI, there will be again 2 scenarios. A person may be independent in looking after himself, like, the day-to-day, regarding his upkeep or his requirement of food or his pocket money, whatever. But he will need an assistance. That will be one scenario. The other would be like he'll be put in a rehab. And there not much, you just pay the amount, but then again, whether that person, the PMI who is in the rehab, you need to monitor, someone has to monitor whether he is being taken care properly in the rehab. So these are so many questions which we have. How do we incorporate this in? We will not there. Or maybe 10 years down the line when the parent or is around 70 or 80 and he is not in his lifetime only, like we have to hand over everything to the trust only. So these are so many questions which we have.
Thank you. Yeah. Okay. So, one thing, remember, before, okay. Okay, thank you. We understood the concerns of MRMRao and all other caregivers. Before she answers the legal aspects of it, the management aspects of the trust is what she attached to one thing. Secondly, as a settler, you must have a very clear mind, because advocate will not have what he has to do with you. And there is a diversification of assets. Each caregiver is not same. His immovable assets, his ancestral property, his own earned money is different, and his movable and immovable assets are different. So it is not common. So each trustee is unique, which you have to discuss clearly what is in your mind. You must be very clear about it. There is no doubt about it. It's not common to all caregivers. Difference is that. And one more thing is, as far as management of the trust is concerned, it depends upon the trustee you choose. If you are trusting that he will handle it as per the need, and if a person is in rehabilitation, and the trustee has to only transfer the rehabilitation fees monthly, whatever you write there. He has earlier the work is being done by you as a caregiver. Now you are handing over your work. That means he will execute the deed, stepping into your shoes, and you have to choose the trustee, such a trustee that you have to apprise him well in hand how you are giving care. And same care has to be, you have to train. If the trustee is not trained in caregiving, you have to train him how you are handling, and then hand over the management of the trustee to him, so that whatever doubts you have in your mind will be taken care of by the trustee. That is one thing which before I giving you, because an advocate can only give replies legally and legal aspects of it, and the management of an aspect is between the trustee and the settler. Trustee and the settler. Advocate will not. And the final decision of the trustee is final. Then advocate also cannot interfere. He writes on a deed and leaves it for the trustee. That is one thing. The other thing is Ramakrishna Garu has multiple trustees. That also I will put in. Too many cooks spoil the broth. Too many cooks. And one more thing is, let me clarify that if there are so many trustees, there is only one trustee who is the executor. They cannot be all the three executors. If all the three are the executors, they will fight among themselves and they don't want. And normally when there are multiple trustees, they will elect and give authorization to a managing trustee to operate the trustee. There can be only one cook who can cook properly. If one put salt, another put your chili powder, then you are bad taste. So, in that case, in the trust deed itself, you have to say that if that also as a condition, that trustee 1, trustee 2, trustee 3. Like after his operation is over, the trustee 2 will take care of something happens to the trustee so that the continuity of the trust can go on. Yeah, backup can be there. And they can also create a trust for your information. The trustee whom you have allotted can be given power to create another trust by himself, because if he thinks I cannot manage now, he himself can create another trustee of his own trust, and then this will continue. Okay, with this small, I will give the mic to.
I completely agree with sir. Ma'am, questions yours, I understand that being a mother, you need to protect your kid after you, right? Again, I'll come to a point. Private family trust is something where very, very, very carefully you need to select a person to whom you want to give that power after you, that he or she will look after your kid. Regarding PMI, see, ma'am, we cannot control future, but we can get secured for future, right? We can take the steps to protect our loved ones through this private trust, right? And most and more important thing here is, in case of PMI, you can add special clauses only. There will not be a kind of a special clauses, but only the, in that case you can go with, like, a trustee along with a CA. Your question was like whether how finances will be managed and who's going to look after and everything. In fact, in Rajesh case, I agree that he had 2 normal child, but it is not a very different matter in case of PMIs, ma'am. As sir already discussed, like mental act in our India is not so much like oppressed by the government, to be honest. So here we need ourselves to protect our kids, and we need to become a protector for our kids after our death. And to be honest, if I'll to all your questions regarding that, I would definitely like to join you personally, ma'am, that where I can satisfy your all the questions. And moreover, it's all, again, I'll say the same thing. It's completely depend upon your choices, that what you want to put in your trust, to whom you want to give your things, controls, everything. I have already mentioned earlier that private trust is not just a legal document. It is a weapon to protect your loved ones. So you need to be very, very careful regarding while drafting it. And I agree with the sir as well that being an advocate, I will definitely going to share. Okay, ma'am, in your case, you need to add this clause. This is my opinion only. But I cannot force you to put that clauses. Definitely, I'll be sharing those clauses with you to protect you legally. Okay, but I cannot assure, being an advocate or a legal person, that where I can assure that, okay, this trustee will take care of your kids or to PMIs. Regarding the medication and dependency and everything, again, I'll come back to the same point. You can terminate your trust anytime when it is breached. So it is kind of a document where we made it. very carefully, where every and each of your questions will be got answers. But only the main important point is how we draft that trust deed, what clauses we put in. You can put unlimited clauses, no problem at all. There is no restriction of the pages that you need to stick with 20, 15, 5, 10. No, you can make this much. 200 pages also if you are not satisfied. Until you are satisfied, you can make each and every clauses. But ma'am, we cannot protect future. We cannot go with that assumptions that what is going to. We are finally humans, right? Ultimately something will go. We can only. This is the unfortunate fact about being a human, where you cannot protect yourself from future, but you can get secure. But again, I'll come to the point, security is only 99.99%, I guess. 1% is still we are unpredicted, ma'am, to be honest.
Parent had formed a trust, and the trustees were the mother's sisters, Marcies, and very close relatives. 2-3 people were on the trust. Actually, what I'm trying to tell you is there are chances that we may miss out on 1 or 2 clauses. Then what is the scenario? So these are live cases, the 2 cases which I am telling. You can give us the answers. So then what happened? The person who has written, she expired, and the trustees started implementing whatever was in the trust. In that she had forgotten to mention the house, the immovable house, which was occupied by the PMI. And it was not written in the trust, because she assumed that this PMI will continue staying in that house and he will not have the power to sell the house. But she didn't take care of that clause in the trust. Now the PMI suddenly wanted to sell off the house. The trustee didn't know what to do. So that was one scenario. Now they were in the trust deed, it was not written that they have to stop the PMI from not selling or whatever the relevant clause. I don't know the legal language of it. That is one case. So she was lost. She started asking us, because we being friends, she had asked us how to solve this. I said, I don't know much about it. You have to take legal help only, but the PMI has a right to sell out because the house is in his name. Means after the mother, it went to his name. So he has every right to sell it off. She should have included that part also, that he has no right to sell. He has only the right to occupy the house. That is one case we came across. Second case is the father, he had clearly written that after his demise, the PMI son will be shifted to a rehab, and rehab whatever needs to be given and all that was and immediately it was implemented by the trustees. The PMI was put in a rehab, everything was going fine till 2-3 months. The PMI refused to stay in the rehab and he wanted to come back to the house. That was not written in the trustee, because it was confirmed, because the PMI was around 65-70 years. So the father or the person who wrote the trust or trustee, he thought that that was the suitable, he took the decision on behalf of the PMI. Now he escaped from the rehab and he is back to his house. Next what?
again, ma'am put it like three situations here. First is that trustees were Masi and near relatives. First mistake. First mistake, ma'am. Though becoming an advocate, if I'll say, ma'am, okay, I don't think that it is my advice not to put trustee to your near relatives. Will you be able to listen to me? No. You will say, no, no, ma'am, I have a faith on them. Right? Just like sir said, Ahmed sir said, no, abhi tak to kisi ne kuch kiya nahi hai, I trust. We are Indian families and we belongs to India, and we are living in a society where we take decisions from not here, from here. Still we trust, right? Ma'am, again that Masi, automatically Masi, Atama, I don't know, Chinnamma or Atama may be the Telugu word. I am very bad in Telugu, still learning in process. Maybe in next session I'll assist you in Telugu language. But I don't think so. I mean, I am also a mother. I cannot trust my kids with like my Masi and my anyone. So you are the, okay, you have a PMI, right? But your state of mind is correct, na? You're in a good state of mind. That is why that PMI is completely depend on you. That is why what I said, ma'am, you need to be carefully choose the person to whom you trust. No, ma'am, it is automatically you have given every kind of that meal in front of the relatives. Okay, go and eat it. Kind of a thing. I mean, trustee should be someone, ma'am, with a genuine heart, with a neutral attitude. It is not really important that that should belong to your family only. Maybe your friend, very close friend, maybe a neighbor who is just being with you in your hard times. A person who is in your hard times can become that person, not in a person who is in good times. I mean, I have that much... Again, we missed, na ma'am. We missed that clause. That being a parent, we need to decide that we should be aware. Here I will say like 99.99% we can be accurate, but not 100%, ma'am. We can also slip with some things. Yeah, if PMI is not ready to shift it to rehabilitation, so his father would have known that, right? That he is not comfortable with the rehabilitation environment. He is more comfortable in house.
I would like to clarify two things here. One thing is whether it is breach of trust. In the trust selling, the aspect is forgotten. Okay. And PMI is now cognition and he wants to sell it. He is in good mind. He is taking medicine and he wants to take his own decision. One thing. Okay, if he is in mania and wants to sell the house, and if the trustee believes that this decision by him is in unstable mind, he can go to court of law, prove and stop that selling as a trustee for the benefit of beneficiary only. So he has to prove to the court of law that this particular property selling is not in stable mind. If he can prove to court of law, then his decision may be in court provided. But if the PMI, who is also have human rights, can engage another advocate, he can also engage another advocate who will prove that, he may prove that his decision is right, he is in good mind. So it all depends upon your trust deed which you are preparing may not can be challenged by only PMI. Nobody else can challenge. But if a PMI doesn't want a trust, he can go to court and say, I don't want this trust to manage my assets. That also can be given by and a PMI can go to court and squash this entire trust. If he wants, I can manage myself.
Yeah, that should be revocable trust, not irrevocable trust. again the clause came. Yeah, if it is revocable, okay, fine. But if it is irrevocable, then can't do anything.
Trustee and the PMI, the litigation will continue. PMI. So it is more than the PMI. Now I request Rafat Raja Madam, our secretary, active secretary, and Dean of Ankur University, and so many titles for her. She is also faculty, taking counseling, she takes counseling. She is a faculty in nursing college.
Yeah, so we can add here with like that trust, we can add a more medical, we can more concentrate on the clause of the medical situations, ma'am, according to the disease. That here we can manage that clause once we will get the detailed condition about the PMI. So according to his condition, we can make this trust deed as well.
Please understand that disability certificate is not permanent, because a mentally ill person, once he becomes stable, he is working in office and other places also. So they say if it is disability is 40% or more, then only the disability certificate. So it is reviewed. So you cannot say that he is a permanently mentally ill. That is also there. So anytime the mentally ill person who is the beneficiary can challenge your trust deed if he doesn't want a trust. I am putting it very clear that you cannot brand him as lifelong mentally ill. That is one thing. Okay.
The most important thing is the very basic thing, ma'am. You are aware about your PMI's condition. Like, again, very wisely choose your trustee. Very wisely choose the people to whom you want to give all those authorities again and again. Take your time for, like, before, if you are taking decision regarding, like, okay, I want to go with private family trust. Fine, take your time. Think about everything and put it down on the paper. Revise it. Yeah, sure, sir. Because yeah, then it again, ma'am, it depends upon person to person. Because in my knowledge, there are multiple kinds of, as you said, like, or talking about the mental thing. Yeah, if he is working, he is earning money. That is a challengeable in court of law. Easily, where he can break down. Okay. we can, I can personally help you with, like, at an emotional level also. That, okay, ma'am, I'm a woman too, I'm a parent too. I can, like, no advocate will do that. But as I mentioned in my profile, that I want to literally help everyone. That is, remember me for their lifetime. Okay, thank you so much. Thank you. So, yeah. Oh, ma'am. Ma'am, assurance is, finally, I don't know how to put this. But, thank you so much for that respect, ma'am. I'm really very pleased, actually. Yeah. Yeah. it, it is kind of a, like, you're just making a picture and looking for a hero and heroine kind of a thing.
Good morning. I'm also a caregiver to my son. I have property and it is self-acquired. Like I was saying, I'm a caregiver to my son. I have self-acquired property है, तो मैं 2010 में शायद एक ट्रस्ट बनाई थी, but now the objectives are different. So can that be, one question is whether that can be modified, क्योंकि अभी ये जब PMI नहीं था, अभी PMI है, तो that is one thing. And then I would like to have your card so that personally I can meet you and we can go about that.
So to ma'am's question is, again I'll come back to the madam made a trust like years back. Again my question is whether that trust is revocable or irrevocable. If it is revocable, we can modify it, no problem at all. If it is irrevocable, we can go with a cancellation of trust, right? Yeah. Then after cancellation of that trust, we can go with a new trust. So where we can mention that PMI, now the person is literally a PMI. So according to that, we can go and we can put the trust deed and we can draft that.
Number of trustees, like only one should be there, or can we have more? Like sir was also having.
I think sir has given the good example. Many cooks actually, they ruin the food. Same, जितने लोग ज़्यादा किचन में आएंगे और वो खाना बनाएंगे, उतने ही लोग कोई मिर्ची डालेगा, मसाला डालेगा, कुछ डालेगा, तो अल्टीमेटली खाना खराब ही होगा. Better you can have only one backup, I will say. Along with that, you can have a like declaration deed. Declaration deed. Along with that trust deed, you can have a declaration deed. Okay, in that declaration deed, we can put like, okay, if this happened, then this is the backup plan. Yes, with plan A, you need to have a very secret plan B. No one should know. Everyone should know, okay, we have only trust deed. Then that paper should come out when we are in a situation of needing that. That is what I called as a backup deed. I mean, it's my word, not a legal.
Yeah. Can PMI be one of the trustees? Not a trustee.
To whom we are giving like, control, people with a good mindset and a controlling power with a neutral attitude. So PMI, they cannot become a trustee here. Yeah, he can become a trustee, but a beneficiary, he'll become definitely PMI.
గారు మీరు వచ్చి మీ
guardian. After me, now my daughter took green card in America. Yes. Now, after for that only it will go for all other properties which I will give to her after me. For that also, I put her as a guardian. They will number as a my వచ్చే ప్రాపర్టీకి దాంట్లో కూడా నేను గార్డియన్ పెట్టాలా అమ్మాయి కండిషన్ అంటే దానికి అంటే ఇప్పుడు ప్రస్తుతం స్టేబుల్గానే ఉంది కానీ ఏంటంటే కొన్ని మర్చిపోతూ ఉంటుంది కొన్ని నార్మల్గా ఉంటుంది కానీ ఒక్కొక్కప్పుడు ఇలాగా వస్తుంది అనమాట అప్పుడు వాట్ ఎవర్ చేస్తుంది దానికి even though she can remember 20 years back things also, now she can tell. But ఇప్పుడు జరుగుతున్న వాటిలో కూడా కొన్ని మర్చిపోవచ్చు. అంతే కాదు ఈవెన్ కుకింగ్ చేస్తుంది అనుకోండి నువ్వు వేసిందో లేదో మర్చిపోతుంది అలా ఉంటుంది. వాళ్ళు 80% అలా ఇచ్చారు కాబట్టి వాళ్ళు ఆఫీస్ వాళ్ళు స్పెషల్ శాంక్షన్ చేశారు.
Again, ma'am, in your case, like, I'll ask you one very personal question, like, do you believe that after you, that your older daughter will take care of your daughter? See, that is the problem. Yeah. Yeah. Right. Yeah. And is your will registered, ma'am? Yeah. So, no, in your case. That is like a self-fund, consider that. Because your husband has given cash and you bought that property, right? So, yeah, fine, no problem at all. It's a self-acquired property. Okay. So, the thing is, like, in your case, ma'am, I think you need to write a very good will, with a detailed will, along with a make it trust. That is the good beggar. No, you can't. In trust, again in trust, you cannot put. Yeah, you can put like, you can choose your person. While like, yeah, but outsider will be like, only one outsider will be there, CA. Yeah. Yeah, you can go for it. Na? It's fine, no problem. You can handle from like, anywhere you are. Okay. So yeah, you can write a will, ma'am. But to be honestly, like, for the more protection after you can go with private trust. That is my opinion regarding your case. Yeah. No, you can make a trustee to your daughters. No problem at all. And beneficiary to her. If she is married, then it's a big question then. That then talk about like her husband and family then.
Thank you. Okay. If you are trusting no one, there is no trust deed. One more thing is, you are putting all your money in a bank. How do you know that bank will survive? How many banks have collapsed? How many cooperative societies have collapsed? And with all your trust, believing that the bank will be lifelong, you are putting your money into a bank. And we are forgetting that you cannot trust yourself. When you trust yourself, morning you are with anger and evening you are very cool, or the reverse of it. So there is no trust on yourself itself, how your mind acts, how your brain and what are your emotions and other things. And it's only people like Ramana Maharshi and Swami Vivekananda who have balance of mind. Not all of us. That is one thing in general. And mostly I expected questions, general questions, but here come out with each personal question. But still Advocate Jyoti Srivatsav Madam has answered in personal questions, and she is willing to give her advice personally also when we meet her and all. And no, yeah, that is, yeah, trustee, yeah, everything trustee. Or if a trustee gives chartered accountant, he can empanel a chartered accountant who will see into the.
That you need to file everything. No. Once it got registered with Indian Trust Act, under Indian Trust, then that document is up and running. Then you have to face the legality. So you have to yourself decide whether to get registered that document or not. Okay. No, ma'am. Up to your wish only. If it is like, yeah. Okay. Well, in that case, nobody goes together. That is the fact of our life. So maybe if from one parent is there, right? Mother or father, take anyone. So you can mention a clause with a trustee. You can make mother or father attached with that trustee, along with that trustee, along with that CA, so that you can have an eye. It is not compulsory. While after you can execute, after you're you can execute and you can put a clause that this trust will be get updated and up and running after my death. But if it is not restricted that you cannot make a trust while you're alive. Yes, you can. Definitely you can go and you can make a trust and you can put one of your spouse or like any one of you can become a trustee, no? So you can keep an eye on that, and that time you can up and running, that can get registered and that can become an up and running. Yes. Just a paper.
One question here related. Okay. One question related here: transfer and management of assets. Is it with immediate effect or after the demise of the asset owner? It is already answered. Already answered? Yeah.
Rajesh example, that he was alive. He made that trust. And that trust become up and running when he when he died, right? So it depends upon ma'am. Like trust is something, a beautiful document. It's a very beautiful legal document where you can do makeup of that document as per your wish. Anything you can put it, whether you are alive or whether you are died. Whether you want to execute while you are alive, it's okay. Whether you want to execute after your death, Yeah. Yes, when it is registered and up and running.
Then what is the minimum and maximum number of trustees is also answered. Okay. Is there any requirement that a family member needs to be one of the trustees? It is very important. Outsiders, like outside. And one more. No, I think I have already answered it. When there are, I have already answered it. There is an executive trustee. They will elect an executive. All the trustees will not do the day-to-day operations, but they will overall supervise the decisions taken by him as to be put to the other trustees and get ratified, so that the trustees will, the other trustees who are not executing the trust conditions, I think.
One more point I would like to add on here, that you can go with a clause where if one decision is taken by some one trustee, so you have to put that clause that, okay, without consulting beneficiary, without consulting any other trustee, without consulting any member or a trust related to person, like board of members kind of a thing, main persons you have to got elect and take their permission. If they all are get agree, then this decision will be get forwarded. There are n number of clauses, ma'am, where you can protect. Or majority or by ratio, like 3:1, 5:1. That is human nature, ma'am. We get disagree to many points, right? That is why we are here to like protect our things, right? So where unless and until we will get the clear idea about like, you know, what we are putting in deed. That is why again and again I'm just putting the main point here. Just think. And just wisely elect the person.
And it is time and again told that there cannot be too many trustees. It will be a problem, legal issues. The trust cannot run with too many trustees. Even very high level trusts are also defunct because of the litigations. Our decision making is becoming very difficult. Too many trustees. No. Protector.
According to their disease, what they are facing and what kind of a disease they are facing right now, what are their behaviors, everything. That on that report, that trust deed will get drafted. And don't give that trust authority, no. Just make him beneficiary only. Beneficiary don't have a right, don't give them right, no. Here you need to be very, very clear whether PMI is able to, like, I agree that sometimes they are like very low, sometimes they are very high, their mental balance is not like kind of a, like, you know. So ma'am, here I will suggest you that you can go with a surveillance kind of a team, as I have mentioned that backup plan B should be there. Plan B. am really very, ma'am, I am really very sorry that I am asking you this. Are you 100% sure that if you will make 4 to 5 trustees that they will run smoothly? Voting can be ma'am, you cannot challenge anyone's sense. As greedy people, they are around you. You don't have a sense of them as. I mean, next to you, sitting like nowadays, family litigation is so much in court, you will not be able to think that, okay, this is the relationship. I mean, just talking about you said, right? I've seen in court, like, just 10 days happened to marriage. They came from honeymoon and they stood in court, family court, that I want a divorce. Where is that sense? Nothing. That mother and son, where is that sense, ma'am? No one has got sense. If money comes now, everyone get greedy. You cannot assume that, okay, he is a sensible person, he will take decision for your son or your daughter. Trustee has got a good financial benefit, ma'am. He is the, what you will say, he is the ultimately controller of everything. Not custodian, he is a controller. He is the boss. He is the boss of every single transaction of the trust. That is what in the starting I have mentioned, that most important thing is you need to select a person very wisely, because you are giving all the meal in front of him to eat. No, sir, you have to be very clear about that in your trust deed clause. You need to put that clause that no one can sell that.
I think
so that is why we covered every clause. Exactly. Backup plan, plan B. No one will suggest you all these things, because I can sense that you all are parents which are thinking about, like, यार मैं चले जाऊंगी तो क्या होगा, मेरे बच्चे का क्या होगा, because more important, like जो 9 महीने हम लोग वो चीज से गुजरते हैं, we know that कि what pain we face while giving birth to them. For being a mother, for us, it is not important whether that child is PMI or normal. Mother is mother. Father is father. I can relate to that sentiment, to be honest. I can feel that, ma'am. To be honestly, I mean, it's a scary thing that you all are facing. Yes, ma'am. Ma'am, 34. That is really very scary thing to think about. Ki what? Okay, ma'am. Advocates. Yes, ma'am. Outsider. Well, in this case, ma'am, I would like to share one thing with you. Actually, I went through a case. Actually, a case came to me. It was related to NGO, and trustee was like, all the family members, close family members. I mean, 2-3 trustees were there, and all family members was like, very confidently they made like, okay, fine. And they and one trustee was like, ma'am, CA, and they landed up in a very bad situation, ma'am. Very bad situation, because it's a work ethic and protocol that I can't share many details about that case. In this particular case, family members, they betrayed everyone. And that CA person who quoted outsider, he saved that person, ma'am. He went to court, even that wasn't his job actually. Okay, fine. They offer, family members offers to CA that, okay, fine, that we will offer you this much amount, you need to just, give testimony in favor of us. but he stood against that person, against those family, and he saved that particular beneficiary, ma'am. So in case no one can quote that who is our well-wisher or who is not. It can be outsider, ma'am, who can go like beyond their limits, and it can be your family member. Or maybe other outsiders can ruin it, or maybe your family person, own family members can ruin everything.
It's all about trusting others, and most of the questions are in general in nature. How can you control the character and control of people lifelong? One thing. So another aspect of this is question, madam. Question is: can a public trust be one of the trustees? Public trust be one of the trustees of the?
No, that is very risky. How he will manage like public and this one? He'll eat two sweets, no then. He will getting the benefits of like, from public trust as well and from private trust as well. So person with a double responsibility should not give another responsibility, in my opinion. Legal in the sense? No, it is not. Not as well. Not strictly as well.
Can the terms and conditions of the trust be amended, like change of trustees, etc.?
It is back to our topic, revocable, irrevocable. Depends. It can be amended, but if it is revocable, fine. If it is not irrevocable, then we cannot do anything. We cannot amend. Once drafted, once registered, once up and running, once filed, taxes, everything, you cannot do anything. Then clause will only safeguard you. Ma'am, only one time. Then again you have to go with the cancellation of the trust, and that is a very lengthy procedure. While making private trust, that is to private family trust, you need to be very, very, very sure. 99.99% that has to be watertight.
Now the questions are over here. Ms. Pranati to come, Pragna to come and ask in brief one question, because time is up. We have to close at 12:30. You are allowed one or two. Okay, please come.
I want to go for surrogacy. What is the process?
First of all, ma'am, surrogacy is still a taboo in India. Taboo in the sense is not accepted by the Indian society, though it is accepted by Indian government, but it is not accepted by the Indian society. It completely depends upon whether your family is and procedure that to whom you are like want to make MOU. It's okay, but there is a deed where we can draft that. Okay, so in that draft, that is registered with the notaries, and details should be there of the surrogate mother. Yeah, you need a letter from doctor, and moreover, you need a concern letter, concern authority, declaration affidavit from that particular woman. Yeah. Only for PH, but it depends, like PH in the sense physical handicap. Okay, for being mental handicap, I will say this is like not legal. I am telling you. Okay, to be clear, you are talking to me. For me, you are sounding good. Okay, unless and until you are clearing your exam. That is, in civil services we have 3 steps. first is preliminary exam, prelims, then the second is mains, and the third one is interview. If you're clearing that, prelims, okay, fine, you're good to go. You're clearing mains, good to go. Ultimately, the final will be interview. If you're getting cleared, that means you're mentally fit. Yeah, you are medically fit because you're talking to me very now. Yeah, then doctor can give you, na. Doctor can give you an, certificate. You're talking to me, and moreover, you're thinking about like becoming a collector. That is making you you're normal. Who told you that you're not a normal? Thinking about becoming a bureaucrat is, you're very normal. So you can go and you can study, but study very hard. Here my one question to you, your property means to whom property? Is your husband's property or your... So definitely your husband's property belongs to their parent, first of all. If you want to make a your land related matter is only if your in-laws are harassing you, they are ma'am. Okay, so what is your motive to know about that? Okay. Yeah, so here in your once become an IPS officer or IS officer and take their classes.
Ragna, please take your seat. And I spoke to her over phone also number of times, and there is some sort of a family conflict and dispute. I think I also advised her, or who is her well-wisher. If you please find your well-wisher, that is a different question, not to the advocate. It is a sort of family, within family, that sort of. Now, we have a felicitation function of our guest faculty. Please, Rafat Raja Madam, please come on to the dais. Secretary and Anuradha, please come and felicitate the guest speaker along with our Secretary Rafat Raja. Okay. I think we have come to the end of the session, and we had a very nice session. Before we conclude, just a few, 1 or 2 minutes, I request Raman Srinivas, please come and give your last final message. Then we can conclude.
I can say that it's a very interesting and interesting session. As the different issues here, as an advocate, you need to look into the document and we can advise it accordingly. Please,
I would like to say thank you so very much that I met a very beautiful people. Again, it's not your pleasure, it's my pleasure, obviously, that I like to take your life experiences so that I can also protect my son or my daughter and my family. And not being an advocate, but being like human, and moreover, being a woman. I am always available for all of you whenever you need me. As like, I will definitely going to help you in my field legally beyond my limit. I can promise you that 100%. You will not face anything like, oh my God, that Jyoti was like very bad. No, I need all of your blessings and your wishes for me, and hoping to get your experiences which I can count in my profession as well. Thank you so very much. Thank you.
So, thank you on behalf of ASMICA, our Chief Guest, Jyoti Srivatsav, and we have very rare advocates we find like this, who can spare their time and give personal advices rather than taking a PowerPoint presentation and blah blah blah. This PowerPoint is blah blah, nothing but blah blah, reading the lines in between. So I thank Srinivas also from all the way and spared their valuable time, and thank my friend Varun Srivatsav, who is very intelligent and very knowledgeable person and has a very rich experience, and because of Varun Srivatsav, who was playing a chess game with me, I had the opportunity of introducing myself to Jyoti. I thank him very much, and also they come all the way. Yeah. So I also thank the video, Mr. Hanumantu, Shiva, Mr. Shiva. And in fact, we were struggling as senior citizens, myself, my sister, what to do with this. Then she arranged, and they are obliged to come here and spare almost 3 hours with us. They are professional videographers, not like they are professionals and a team of people covering the entire city. And they are with us today, and I thank them all, videographers. Hope they will cooperate with us in our future program. Thank you all. Thank you very much. And we conclude the meeting.